Ladies and gentlemen, welcome at this web lecture in which I will explain the difference between monism and dualism in the context of international law. Treaties are agreements between countries. They could be bilateral, so that is two countries agreeing on something, and they could be multilateral. That means a group of countries agrees on something. In the economic domain, for instance, we can agree on rules that reduce trade barriers, for instance. The question is, the content of these international treaties, how do they at some point end up in the domestic legal orders of the member states so that they can be used by its citizens or by the institutions that are addressed? Well, this can be done in two ways, a monistic way and a dualistic way. And to explain the distinction between these two approaches, I often make use of the classic coffee machine. The idea is simple. International law is put as coffee on top of the machine, and at some point the coffee has to end up in the coffee can below. So to do that, it has to go through a filter. This filter can be compared with the constitutional mechanism of a member state, and the filter can be of a monistic nature or a dualistic nature. This says a great deal about how the international agreement ends up in the domestic legal order in itself and can be used as such. In a monistic system, international law forms already an integrated part of the domestic legal system. There is not really a distinction between the two of them. So once the country closes an international deal, it automatically forms a part of the domestic legal order. So the coffee goes easily through this filter, and there is no need for an additional action for instance, the national parliament or something like that. So the international law does not necessarily have to be transformed into domestic legislation. It is already a part of the domestic legislation. The dualistic system is slightly different. In a dualistic system, the coffee will not get through the filter just like that. A national parliament or a national ruler will have to transform the international agreement first into national law and use the national procedures to adopt this legislation. So a transformation must be made. Well, examples of a monistic system are, for instance, Japan, Russia, the Russian Federation, and the Netherlands. Examples of a dualistic system are, for instance, Great Britain, Canada, and Italy. So, are countries 100% monistic or 100% dualistic? Well, mostly not. Take the Netherlands, for instance. We officially are a monistic system, but with some background checks, if you like. So, for instance, our government first has to publish an international treaty before it can be an integrated part of the domestic legal system. Only when this is done, it is a part of our domestic legal system. And this means that the government has a choice, can we publish or not, to make this a part of the domestic legal system. Another element to it is that a court in the Netherlands will only use those elements of international law in a court case to apply it when these rules have a nature that it is actually useful, that it can be used in individual situations. So the rules should be specific enough to be used in individual cases. They should be applicable on all persons, we call that. So in that sense, we call the Netherlands not necessarily a monistic system, but a qualified monistic system. And what we see around the world is that in each and every legal system we have those elements of monism and dualism. And some countries are more monistic and some countries are more dualistic, but they barely are 100% monistic or dualistic. So studying this particular filter is really important to fully grasp the meaning of the Constitution and the way international law will end up in the context of the domestic legal order. Well, thank you very much for watching, and I hope you've learned a few things about monism and dualism in the context of international law.